All rise. Oh yay, oh yay, oh yay. The Honorable Court of Appeals of Tennessee is in session. God save the United States, the state of Tennessee, and this honorable court. Please be seated.
Good morning and welcome. We're pleased to have all of you with us today. I'm honored to be sitting with Judge Stafford and Judge Golden. As hopefully you know, the Court of Appeals of Tennessee is one court, and all 12 judges hear cases across the state. We're not just a section, and so it's my pleasure to be here today, and I'll be in Knoxville next month, and my two colleagues will be coming to Nashville and Knoxville as well. So we're thrilled to be working together and pleased to be here to hear your cases today. Please recall that each side has a total of 15 minutes, and that applies whether there's one or multiple lawyers arguing. If there are multiple lawyers, you'll have to share the 15 minutes. The appellant does have the opportunity to reserve up to 5 minutes for rebuttal. So after you've come to the podium and introduced yourself, let us know how many minutes you wish to reserve, and the clock will be programmed accordingly. Are there any announcements or introductions? Yes.
Good morning, Justice Clement.
Good morning.
My name is Marty Kaufman. I am a member of the Memphis Bar, and I would like to introduce to the court my newest associate and my youngest son.
Very good. Nice to have you with us, and I want you to know that we enjoy chewing up brand new lawyers. And so,
And I hope you do.
good. It'll be good for him. Well, welcome, and we're pleased to have you here, and I'm confident that your mother will let you know if you made any mistakes later.
He will actually not be arguing today, and just for reference, his name is actually Zachary Kaufman Monroe. I practice by my maiden name.
Very
And
good.
if he comes before the court,
Yeah.
his last name will be Monroe.
I practice by my maiden name too, so we have that in common. Good, excellent. Okay.
Good taste in naming.
Very good. That always reminds me of the opinion of Rose by any other name when Rose Cantrell sued the Board of Law Examiners
Yes, sir.
to be licensed under her maiden name.
Yes, sir.
The board said no, and the Supreme Court said yes. And so anyway, and the Supreme Court was right. They're not always right, but they do have the last word. But anyway,
Yes, sir. Thank you very much.
all right, thank you. Judge Stafford?
Just as an aside note, please have a seat. I can't think of a worse situation. I'm glad to hear you're not arguing, because I would hate to know that I had my first oral argument with my mother sitting there watching. It would, no, I don't even want to think about that. Two things. One, Judge Clement failed to mention that these oral arguments are being live streamed. It's a great thing, but it's also something that anyone who is arguing needs to think about. So please think about what you're going to say before you say it, because it's much akin to the old toothpaste in the tube proverb. Once it's out, you can't take it back. So once you say it, it's out there. So please think about that. Second thing is, I wanted to thank Judge Clement for joining us today. He's always a delight to have on the panel, and as he says, we all travel across the state. We're in Knoxville, we're in Nashville, we're here and in Memphis as well sometimes.
Sometimes in McKenzie and sometimes
That's
in
right.
Memphis.
We were in McKenzie last year about this time. But we appreciate him as well as all the other Court of Appeals judges traveling, and it's always a delight to have him. And I'd say the same about Judge Golden, but he's with me all the time pretty much, so there you go. Thank you.
All right, thank you, Judge Stafford. Are there any further announcements? Yes.
Lauren Stimmick from Glassman, Wyatt, Tuttle, and Cox in Memphis. I also have an associate with me who has not appeared in this court before, and so if I may, I'd like to introduce him. This is Hayden Davis. He's a graduate of the University of Memphis Law School and the newest associate at our firm.
Very good. Well, congratulations as well. We're glad to have you with us.
Thank you.
Thank you. All right. Any further announcements? Hearing none, call the first case, please.
Mitchell D. Horst et al. Versus Gary Gaar.
May I approach, Your Honor?
You certainly may.
Thank you very much. If Your Honor, please, I would like to reserve, that's really loud, am I being too loud?
That's quite all right. You're doing just fine.
Thank you. I had a chancellor tell me earlier this week I wasn't being loud enough, so. I would like to reserve 2 minutes for rebuttal.
2
please,
minutes,
sir.
certainly.
Yes, sir. If it please the court, my name is Marty Kaufman. My office is located in Memphis, Shelby County. Justice Stafford, Judge Clement, Justice Golden, it's a pleasure to be before you today. I represent Mr. Horst, Mr. Mitchell Horst, who is present in the courtroom, so I actually have to be very careful what I say.
Most definitely.
And an assorted of his businesses as set forth in the style of the case. Mr. Horst filed in the trial court a complaint for tortious interference with a business contract, tortious interference with a business relationship, and commercial disparagement pursuant to the Tennessee Consumer Protection Act. Ms. Stimmick, on behalf of the defendant, filed 2 separate motions to dismiss. And I want to kind of set those out because they interplay into one another. One of the motions to dismiss that was filed is a standard 12.02 subsection 6 for failure to state a claim upon which relief can be granted. The second motion to dismiss that was filed was under the Tennessee Public Participation Act, known as the TPPA, and if it's okay with the court, I think I'll call it that because I get a little tongue twisted in that, between that and the Tennessee Consumer Protection Act and its statute. That's, as this court is aware, the anti-SLAPP statute that is relatively new in this state, and I think is still being interpreted in various ways, both by this court and the Court of Appeals. The trial court granted both motions to dismiss. First, I want to talk about the facts of this case because they're very, very important because of the procedural posture that we find ourselves in, which is there's no evidence, no witnesses, discovery was not had. The motions to dismiss were filed immediately after the complaint. Mr. Horst and his businesses provide investment strategies for affluent clients. That's what they do. Mr. Horst is the former son-in-law of the defendant. Mr. Horst and his prior wife, the daughter of the defendant, founded Select Wealth Advisors, of which the other businesses are basically a spinoff, and ran that company during the course of their marriage. The defendant, during the course of the marriage, much to the chagrin of Mr. Horst, inserted himself in the marriage, inserted himself in the business continuously, as alleged in the complaint, told Mr. Horst what a poor business partner, spouse, etc. that he was, and it caused a lot of conflict. Nevertheless, the parties got divorced. Mr. Horst was awarded the business in the divorce. The defendant, Gary Gaar, assured Mr. Horst, excuse me, I forgot to say something important. During the course of the marriage, Mr. Gaar referred clients to this business. And one of the things that he made very clear to Mr. Horst after the divorce was, I'm going to make sure, and said, I'm going to make sure that everybody who I refer to you leaves your business. Your business will fail without my participation. Your business will fail without the participation of your wife. One of the clients, a lot of bad blood between the parties. One of the clients referred by the defendant is a gentleman by the name of Kenny Ham. He is not a defendant. There has been no direct breach of contract action filed against Mr. Ham. Mr. Horst came to work one day, found out Mr. Ham had moved his assets from the business, was a little bit confused because he hadn't heard from Mr. Ham, and had the following conversation with Mr. Ham. Mr. Ham said, hey, I'm really sorry I did this. I know it's a bad deal. I'm not doing this because of anything that you did wrong, but Gary's been my friend for 25 years and he's instructed me to do this. Gary told me that you were permanently moving back to Las Vegas, which is where the parties lived prior to moving to Memphis, the husband and wife. And he said, because of this permanent move back to Las Vegas, that I wasn't going to receive the same quality and expertise of the services that I was used to receiving from you.
They had a contract, is that correct?
Yes, sir. Mr. Ham and Mr. Horst had a contract, yes, sir.
And that contract gave him the absolute right to move his assets if he chose to?
Absolutely, Your Honor. And would you like me just to go into the issue of breach at this point and tell you why I don't believe that matters?
Sure.
Okay. I'm sure Your Honors have read the briefs and have seen the other comments that Mr. Ham made to Mr. Horst. So there's two different, and that's a great question, and that's where I was heading. Thank you for directing me there, Justice Golden. In the cause of action, tortious interference with a business contract, the element of that cause of action that is pertinent here today is that there has to be a breach of the contract. The trial court found that because there was language in the contract between Mr. Horst and Mr. Ham that said Mr. Ham could move his money at any time for any reason, there could not be a breach. So what the trial court did in essence is found that a terminable at will contract is per se unbreachable. That's what the language of the trial court is setting forth. First of all, I would point out to the court, as the court's well aware because you were all lawyers before you were judges, that most professional service contracts have no termination date. And even though they don't have a specific even if they don't have a specific terminable at will phrase, they are, for example, my client, Mr. Horst, could fire me at any time. And for any reason, hopefully he won't do it while I'm standing here talking, but he certainly has the right to do that. Does that mean that a third party cannot come in and tortiously interfere with our contract and cause a breach? And I would submit to the court that it's clear they do not. If I could refer the court to Black's Law Dictionary when they're defining, and if I may quote, when they're defining breach of contract, here's what Black's says: violation of a contractual obligation by failing to perform one's own promise, by repudiating it, or, and here's what's important, interfering with another party's performance. That is the Black's definition of breach of contract. Maybe this example works.
Do you have any Tennessee cases that support that position?
There are employment cases, yes, sir. For example, not directly in these facts, but for example, in the case of Ladd versus Roan Hosiery, the court held that even though the contract was terminable at will, a third party's interference makes them liable for that breach. Did that answer Your Honor's question?
I'm just asking questions.
Okay. Also, in the case of Cambio Health Solutions versus Reardon, further to address Your Honor's concerns, which is the Tennessee Supreme Court, here's what Cambio said: it is unlawful for any person to induce or procure the breach or violation, refusal, or failure to perform any lawful contract by any party thereto. The important language in Cambio: an individual has a property interest in his labor and the right to work without unjustified interference, and one who intentionally interferes, and that's what we're saying the defendant did, with this right is liable in tort for the resulting damages.
What is the difference between what Mr. Gaar did in this case and a potential employer going to an at-will employee at a competing company and saying, we'd like for you to join our company and we'll pay you 25% more salary? What's the difference in a solicitor, a future employer soliciting an employee away from another company who is an at-will employee?
If I understand the court's question, the difference here is we didn't have someone from, say, Raymond James come to Mr. Ham and say, hey, move your money away from Mr. Horst and his companies and move it to us. What we had in this situation, and I was trying to think of an example, because this is kind of mind-bending to me also, is let's assume that the contract between Mr. Ham and Mr. Horst is a stick. And the contract says they each have to hold up each end of their stick. And the defendant in this case comes and stomps on that stick, not due to anything Mr. Horst did and not due to anything that Mr. Ham did. He then causes the breach of the contract. Does that at all address what you're?
Well, but I'm trying to find the breach, and I think of the concept of breach, meaning that there is a broken promise, a broken obligation. And here, as Judge Golden mentioned, there was no contract that required the customer to stay with your client. He was free to go at any time.
That is absolutely correct. And I think that's why I used the word mind-bending, and I've spent a lot of time thinking about this. And I think the difference is that I think we have to look at the word breach and the legal concept breach different than we look at it in a direct breach of contract action. The whole purpose of the tort of tortious interference with a business contract is to prevent a third party from coming in and causing a breach. We would all, I assume, agree with that. This is not a direct breach of contract action. This is another person coming in and causing that contract to be breached. And I think the other problem is, and I hope I'm explaining this because I've spent a lot of time talking out loud about this, trying to get good examples. I think another way to look at it is that if the ruling of Judge Smith is allowed to stand, and if this court issues a ruling that a terminable at will contract is per se unbreachable for purposes of tortious interference of a business contract, then it takes the right of that cause of action away from every professional service contract or contract that doesn't have a specified time within that contract. Lawyers, doctors, dentists, accountants, money managers. And I don't think that's what is intended by that statute. One other thing, and it's very important to point out, in the second cause of action, tortious interference with a business relationship, a breach is not required.
Well, let me ask you about that.
Yes, sir.
Can that cause of action actually arise when you have a contract? In other words, in this case, there's no question, but there's a contract.
Yes,
It
sir.
happens to be a contract that the one party has the absolute right to leave on. But as I understand it, that cause of action, when there is a contract, can't be supported.
Not sure if I understand
In
the
other
court's
words,
question.
the parties have a contract.
Yes, sir.
And that cause of action exists when there is no contract, where there's a third party that comes in and interferes with a relationship, but there's no contract that exists.
I have read nothing that says that not having a contract is a requirement for that tort, and if I've missed that law, I apologize to the court. But the language of one of the elements of tortious interference of a business relationship is a breach or termination. So if they use the word breach, we're relying on or termination of the business relationship, that the cause of action actually uses the word breach. So I am unaware, and again, I apologize if I'm incorrect.
I think it's being used in a different setting though, but that's my understanding of the cause of action, that if there's an existing contract, that cause of action cannot be supported.
Very well. I'm not going to argue with the court about
No,
what the law is, certainly.
I just thought maybe you might have some response to that.
I do not. Having said that, I think that The only other thing that I have time to address is as to the complaint, the cause of action for commercial disparagement under the Tennessee Consumer Protection Act, the judge dismissed that cause of action for 2 reasons. She said, 1, the statements made by the defendant were opinions. Here's the statement. Mr. Horst is going to permanently move back to Las Vegas, thus jeopardizing the service and expertise that are used to from him. That is not an opinion. That is a statement of fact. They also argue that it's a statement of things to occur in the future and therefore it can't be sustained. I would just leave the court with 2 thoughts about that. As to being a statement of fact, he didn't say, I think he's moving, I heard he's moving, he might move. He said he is moving. That is a statement of fact. It is as to their argument that things that are to occur in the future by their very nature cannot be facts. I would submit this to the court. This court is going to rule on the appeal I am standing here arguing right now. But you're going to do it in the future, but it's still a statement of fact that you're going to do it. And I believe my time is up.
All right.
Thank you, sir.
We'll hear from you.
Thank you for letting me finish my sentence.
We'll hear from you on rebuttal.
Yes, sir.
I will now hear from the appellee. Good morning again.
Good morning again. May it please the court, again, I'm Lauren Stimick, here to represent the appellee, Gaar. Your Honors, this is a lawsuit that should never have been filed. We are here following the trial court's entry of an order granting a Rule 12.02 motion to dismiss and a petition under the Tennessee Public Participation Act. The trial court agreed that this lawsuit should not have been filed, and we ask that this court do the same and end this matter for the appellee with some finality. The appellants are correct that there was no discovery at the trial court level in this case. None was needed. The trial court heard the motion.
Was a motion made requesting discovery?
No, Your Honor.
Okay.
Not that I can recall at this time. If the record corrects me on that, I apologize, but I don't recall that at this time. But, Your Honor, the appellants are correct that the motions that are now being appealed were filed pretty much immediately after the lawsuit was served or service was accepted. And so we don't need to go into the level of facts that were recited by appellants' counsel, many of which today were outside the record, I must point out. What we're looking at is the 4 corners of the complaint. That's the proof in this case. The complaint is sworn in this case. So it is admissible proof, and it does have the contract at issue attached to it. As to the tortious interference with a contract claim, as has been discussed, breach is a requisite element, but I must correct a characterization of the trial court's order here. Judge Smith did not find that the contract at issue in this case was per se unable to be breached. It's not in a transcript and it's not in the order. What the trial court found here is that this contract was not breached. So the ruling is specific to this case, these parties, this contract. The language of the contract, as has been discussed, permitted Mr. Ham to move his money at any time. He exercised that right. That was not a breach of the contract, and so there's simply no claim here for tortious interference with a contract. The same is true for the second cause of action, which was briefly touched on, intentional interference with a business relationship. I agree with the court that this cause of action exists, at least primarily, if not exclusively, for situations where there is no contract, where there is a business relationship, but there's not a contract. And so intentional interference with a contract would not be an applicable cause of action. But this cause of action cannot survive here either, because as pled, and again, in this motion to dismiss, we're looking at the 4 corners of the complaint, the appellants have pled a breach as a basis for this cause of action, and there was no breach. So this claim must fail as well. To briefly address the analogy to the employment law context, the Ladd case and the Cambio case that were raised by the appellants, it's very important to note that in that case law, the courts are careful to analyze the right to work of an employee's property interest in his labor. That is a very important distinguishing factor between those cases and this case. This is not an employment case. There's no right to work at issue. There's no property interest in the labor at issue. It's not an employment law case. That's a very specialized area of the law, and we're not in it today.
I want to ask you about your claim for, under the Tennessee Public Participation Act, with regard to your motion, and as to whether or not it's compliant with Rule 7, as far as pleading with particularity in the body of the motion.
Yes, Your Honor, and it's the appellee's position that that petition fully complied with Rule 7, particularly given the procedural history of the case. So that petition was filed very early on, before the motion to dismiss had been heard. So it was filed, the statutory language was cited, available case law was cited, a memorandum of law was provided as well. Then after the motion to dismiss was granted, a supplemental memo was filed in support of that petition, articulating to the court that its finding on the motion to dismiss provides support for the TPPA petition, in the sense that the trial court had found that the plaintiff could not provide prima facie proof of each element of their claims.
I think the memo seems to talk about if the court granted the motion to dismiss and the plaintiff was not able to substantiate its grounds. But my question is whether or not, your motion clearly states what the Act states. In other words, the legal grounds. But does it have any specificity, any factual basis within the motion itself?
I believe that it does, Your Honor, and I can refer to it here. In paragraph 2, the petition filed September 1st of 2022 states that the activity of Mr. Gaar alleged in the third complaint, there were several non-suits in this matter, is protected by the TPPA as his alleged communications regarding the plaintiff's businesses and services were made in connection with a matter of public concern. Those are all buzzwords from the statute, terms of art from the statute.
That's exactly my concern. You've got all the buzzwords in there, and you've got the statutory language in there, but my question is, where are the facts? What factual basis do you have? What specificity with regard to the actual complaints do you have?
Well, Your Honor, referring at this time, when this was filed, all that we had in the record was the complaint, the sworn complaint, and so those are the facts that the petition relies upon.
What facts from the complaint are in the motion?
Your Honor, the motion does incorporate by reference its memorandum, which also includes further analysis.
Well, is that sufficient under Rule 7? Can you simply rely on the memorandum, or do the facts have to be stated in the motion? That's my question.
I agree with Your Honor that the motion is required to comply with Rule 7. Including additional information in the memorandum is not in and of itself sufficient. But under this situation, in light of the procedural history that we had, because this is filed in response to the complaint, and because of the timing of it, taking a view of it in light of a discretionary view in light of it, the petition does meet the requirements of Rule 7 in the appellee's view, because we were limited at that time to what was available, and supplemented when we were able to do so following a ruling from the court.
What was there factual allegations set out in the complaint that could have been stated in the motion that you're relying on?
Yes, Your Honor, there were, but
there are none in the motion.
We did not repeat the facts from the complaint in the petition. That is correct, Your Honor.
All right.
That is correct. Continuing on with the Tennessee Public Participation Act petition, As articulated in our briefs, and this was not covered by the appellants in their oral argument, but I'll just touch on it briefly in case the court has questions or wants to hear further on it. But this act is designed to discourage and sanction frivolous lawsuits and to permit their early disposition before the parties are required to spend extensive amounts of money on litigation that should not have been filed. This is a prime example of just that type of situation.
The act requires that the statement be a matter of public concern, and the statute doesn't define public concern, but it lists about 6 or 8 subjects, such as the economic circumstances or goods, products, and services in the marketplace. What category does this matter of public concern fall under when we're dealing with a broker and a client and a third party who allegedly interferes?
This matter deals with the good product or service in the marketplace provision, and the reason that we know that, and this was articulated in our pleadings, is that as pled in the complaint, the statements that were made by the appellee pertained to, and I'm quoting, Horst and his businesses. So these are alleged to be statements that were made about businesses, about services provided, and actually services is specifically identified in the complaint, that these were false and misleading statements regarding Horst and his businesses that disparaged the services and businesses of Horst. So the complaint is clear that it does specifically claim that the statements pertain to services rendered by Mr. Horst, which falls into the provision of a service in the marketplace as set forth in the TPPA.
Is that stated with specificity in the motion?
That specific statement is not included in the motion, Your Honor.
In fact, the motion just says services were made in connection with a matter of public concern without any specificity at all as to what that matter of public concern is. Is that correct?
You're correct, Your Honor. The petition does not articulate the specific matter of public concern, except to the extent that, as defined by the statute, the provision of goods and services in the marketplace is a matter of public concern.
It doesn't state with specificity what that matter of public concern is.
Not further than we've discussed.
Then the words public concern.
It refers to the services that are at issue in the case, that are articulated in the complaint that Mr. Horst was providing to Mr. Ham and
Where does it say that? Where does it say that? It just says services were made in connection with a matter of public concern. As Judge Clement said, there are a number of subparts of that need to be stated with specificity. I'm just asking where they are.
And Your Honor, I don't disagree with you, and I acknowledge that the petition says what it says, and we attempted to supplement that as the procedural process of the case went on, but it does not contain a full recitation of the facts in the complaint. I agree with Your Honor about that. It does, however, provide the TPPA provides an additional substantive remedy that courts can look to, and here that's how it was used, as an additional substantive remedy following the motion to dismiss, in addition to the motion to dismiss.
I want to ask you a question about the attorney's fees in this case. As I understand it, and according to the record, the attorney's fees on the motion to dismiss have already been awarded in the trial court?
The trial court has entered an order finding that an award of attorney's fees of $10,000 is appropriate on the motion to dismiss and just over $11,000 on the Public Participation Act. However, the court did not enter judgment on that because this appellate process needed to conclude first.
Was it appropriate to award attorney's fees prior to the appeal?
According
to the statute?
I think it was appropriate for the court to hear proof and to make a finding on that, but the court has not actually awarded attorney's fees or entered any kind of a judgment. There's no order that anyone pay any attorney's fees. The court simply went ahead and heard the proof on that. And I don't believe there was an objection to that at the trial court level. I believe that the objection that's raised by the appellants to that is that because the motion to dismiss should not have been granted, the fees should not have been awarded. So it's more of a substantive argument there rather than procedural, I believe. But
Does the statute allow that?
can you clarify your question? Does this?
Statute on the motion to dismiss when you're awarding attorney's fees. The timing.
I believe that the statute does permit the court to go ahead and hear proof on that, but the statute does not permit the court to actually make an award or enter a judgment, which has not occurred here. So it would be the appellee's position that that issue is not even ripe for appeal at this point, because the motion to dismiss and TPPA petition are the issues to be decided on the appeal, and then depending on how those matters proceed, the attorney's fees would then proceed accordingly.
So if it's not actually an order, a judgment for attorney's fees, what is it?
It is as styled, it is an order. It is styled simply as an order, and the court makes certain findings, but is very careful to hold that execution is stayed pending the outcome of the appeal. The notice of appeal was filed in this case very early on, so there was no question that that was where the case was headed. And so all of the parties and their counsel and the court tried to be very cognizant of that and proceed with judicial economy in mind, but also in compliance with procedural rules and the statute itself.
Judicial economy.
I'm sorry?
How is it judicial economy?
It wasn't a finding made by the trial court, but I think that if I'm remembering correctly, the notice of appeal was filed even before the petition under the TPPA was heard. And so we did go ahead and conclude some matters in the trial court before coming to the Court of Appeals.
In any event, you're going to have to go back, assuming you're successful, you're going to have to go back to the trial court to get a judgment.
Yes, Your Honor, that's correct. I agree with you.
How is that in any way more efficient?
It may not be. It may not be.
Is it anything more than an advisory opinion?
I have not looked at that legal issue specifically, and so I would not feel comfortable giving a definitive answer on that, but I definitely agree that that order is not a judgment, and it does not actually award any money to any party or require any party or attorney to pay any money. So to the extent that makes it an advisory opinion, then yes, it would be.
Thank you.
The last point I just want to briefly mention that was touched on by the appellants, going back to the motion to dismiss, is the Tennessee Consumer Protection Act issue and the statements of opinion that simply are not actionable under that act. I think it is useful to consider this issue in the context of this alleged statement by Mr. Gaar that Mr. Horst was leaving Memphis, moving to Las Vegas permanently, therefore jeopardizing the service and experience that Mr. Ham was used to getting from the plaintiffs. I suspect that if the plaintiffs were asked if that were true, they would say it was not, which very clearly illustrates that it's a point of opinion, that Mr. Gaar would have the opinion that the move would jeopardize the services. Mr. Horst would have the opinion that it would not. It is an opinion, not a fact. And we've cited to very clear law that facts are required under that statute to be actionable. Opinions simply are not.
All right. Thank you, Ms. Dimick, for your
Thank you, Your Honor.
Ms. Kaufman, your rebuttal.
Thank you. Justice Stafford, if I could address the last issue that you just had. There was an order entered. There was an order entered on June 22nd, 2023 that specifically says attorney's fees are authorized under the dismissal of the TPPA. And not only is it maybe just an advisory opinion, I think it's scarier than that. And I do think it was inappropriate. We didn't raise that issue in our appeal, but I'm just addressing what the court said. So there actually is an order, and the order is in the record. Justice Golden, one of the nice things about having young lawyers with their computers in the courtroom is I have found 2 cases that I've not had time to completely review under the cause of action, tortious interference with a business relationship, where it does say, and again, I've not read the entire case, and if you're going to contempt somebody, I suggest you do it to Mr. Monroe in your order. In the case of Robinson versus City of Clarksdale, would the court like the site?
Certainly.
All right, 673 Southwest 3rd, 556, that says a contract is not required for the cause of action, tortious interference with the business relationship, and does not say they're mutually exclusive. Second of all, in the case of Clearwater Partners LLC v. Benson, I have a Westlaw site to that. Am I speaking too fast? 2017 WL 376391, where that case says it is inconsequential whether or not there is a contract. All right. Chancellor Golden, I'm sorry, Justice Golden.
He holds many titles.
He held that one in my county, so. Justice, I was about to do it again. Justice Golden, your question about the skeletal and conclusory argument in the motion to dismiss the TPPA petition, we make this argument as to both motions to dismiss. She merely parrots the words of this statute. And she kept saying, well, we thought we had to do it early, we had to do it early. First of all, she didn't file an amended motion, which she could have done. They did file, the client, excuse me, I'm not personalizing this to Ms. Stimick, they did file an amended memorandum in support of their motion to dismiss, yet did not go back and amend or in any way properly plead that motion to dismiss. There is, as you pointed out, I think that issue's been waived by them, and I don't think the judge, the trial court, should have granted that based on the insufficiency under TRCP 7 as to the way, I think that's 7.08 maybe, or 702, as to the way it was pled. Justice Clement, I don't want to leave you out, since you're gracing us with your presence here in the Western District today.
This will make it worth the drive.
You gonna make a girl blush up here. You were addressing the issue of whether or not it is an issue of public concern. This was a private comment made from one friend to another friend, and we argue that. I would submit to the court it is not a matter of public concern, and that the TPPA itself doesn't even apply. And as to the issue of attorney's fees, it's interesting how this happened. They, in essence, double-dipped on attorney's fees because they got them on both petitions. I don't know if that's inappropriate. I don't know. I don't think part of the problem with the TPPA legal issues is they're so new that there's not a whole body of law out there. But I think I've hit everything I wanted to, and I also think I'm out of time. And I thank you very much for allowing me on behalf of my client to appear.
Thank you, Ms.
Yes, sir.
Kaufman and Ms. Stimick, for your arguments. We'll take this matter under advisement.